Nasreen, yeah, please start. Yeah. You too.
Okay, sir. Good evening, everybody. I, Nasreen Farooq, student coordinator of Pro Bono Club at Kashmir Law College. It's an honor itself who gathered here for the cause of humanity. It gives me a great pleasure to welcome all of you for this great cause. I would like to utilize this opportunity to share my views on human rights and their relevance in today's world that we are all gathered here for. All people on earth have these rights which work for everyone, no matter who they are, where they are from, and they exist to safeguard against harm and violations. Human rights are such rights which each individual becomes entitled to by virtue of his birth. I, Nasreen Farooq, on behalf of the organizing committee, extend our heartfelt gratitude to Dr. Anish V. Pillai as a resource person for our today's session of the one-week capacity building program on the changing dimensions of human rights in India. Dr. Pillai is a distinguished legal scholar and currently serves as a faculty member at the School of Legal Studies, Cochin University of Science and Technology, Kerala. Dr. Pillai is a recipient of Distinguished Young Faculty prestigious award for the year 2017 to 2018. Dr. Pillai's academic endeavor have also been acknowledged globally. Dr. Pillai was awarded postdoc fellowship from the Mediterranean International Center for Human Rights Research at Italy. Dr. Pillai's works include Surrogate Mother and the Law and the Narcotic Drugs and Psychotropic Substance Act 1985 and the Allied Laws. It's an honor to have Sir here. So, we look forward to his insights and contributions to this contemporary topic. It's over to you, sir.
Thank you. Thank you so much. Am I audible? Yeah.
Yes, sir, you're audible.
So let me share my screen. I have prepared a small screen. Hope you can see my screen.
Yes, yes, yes. We can see.
Okay. So good evening, all of you. A very warm, happy Teachers' Day to all teachers. Well, today I will be discussing about interface between human rights and intellectual property rights. Now, I am sure most of you are teachers or aspiring to be teacher or law students. So we have already studied what is human rights. Likewise, you have already studied what is intellectual property rights because we have two subjects like that in our law college. So you all know what is human rights and what is intellectual property rights. Now today, what I am going to do, I am going to just compare how human right is involved in intellectual property rights and how intellectual property right is going to affect human rights. As an introduction, just for the sake of clarity, let me tell you the concept of human rights. So we have number of definitions for human rights. We have our Human Rights Protection Act. Section 2D defines what is human rights, and we have various other well-known authors or jurists have also given definition. But I would say human rights are those circumstances which allow a person to lead a dignified life. So, whatever definition we have for human rights, I would prefer this particular explanation. So, human rights are not even right. It's there are certain circumstances which allow you to lead a dignified life. So, whatever will allow you to lead a dignified life, that is what is human rights. And since it is necessary for your life, you have born with this right. So human rights are not depend upon any statute, any international convention, any judicial decision like that. It is inherent in human being. Simply because you have born as a human, you are entitled to get certain rights. They are, we can call it as human rights. Now coming to intellectual property rights. As we have already studied that, or we all know, Intellectual property rights confers legal protection or legal rights to creatives as well as inventors for their intellectual creations. So when a person invents something, exercising his intellectual creativity, he will be getting a right. And we may call it as patent, we may call it as copyright, trademark, etc., etc., etc. So whatever name we are going to call, but it is a recognition of the intellectual creation of a person. Now, when we talk about human rights and its interface with intellectual property rights, what do you think? Is it complementary or conflicting? Because now we know what is human right and what is IPR. If that be the case, we have to see whether they are complementary to each other or conflicting each other. Can anybody say, respond to me? Can someone respond to me? At least in chat box, we can. Any response? What
Yes,
do
sir.
you think? Being
Yes,
the
yes,
Complement and supplement to each other.
complementary. Okay, that is one of the opinion. Anybody else having an opinion? It is conflicting in somebody. What is that? Yeah, they are also saying complementary. So anybody having the opinion it is conflicting? Okay, let me tell you. Now we will start with the first assumption. They are complementary to each other. So we can discuss one by one how patents, how copyrights, trademark, etc. So if you start with patents, those who are saying it is complementary relation with human right, I do agree to that extent because when you are getting somebody wants to make some comments, I think, yeah.
sure.
When you are, it's okay, it's okay. When we say patents, whenever a patent right is granted, as you know, patent right will be granted when there is an invention. Invention means it's not just a discovery, something which is novel, something which is useful, something which is commercially used. Like that, those qualities has to be there. Then only you will get patent for a particular product. Now, once you get patent for a particular product, definitely that will have a industrialization or commercialization aspect. Now, when a product can be commercialized, only if that product satisfies one particular condition. That is, that product must be useful to the society in one way or other way. So, whatever patented products are there or patented inventions are there, they will be useful to the public in one way or other way. Then only people will spend their money, they will spend their time and effort to invent that. So it's not just like that somebody is inventing for the sake of doing that. It's not. They are spending money, they are investing their time, energy, hard work, etc., etc., etc. And after that, they are inventing something. And for that invention, the law is conferring patent. That means they are coming up with a product which is useful to the society. And when a product comes to the market, if it is useful to us, definitely that will encourage or that will help us to enjoy our human rights. So that way we can say patents having a complementary relation with human rights because all the patents, except I can tell you when we say all the patent, around 95% of patents are in one way or other way contributing to the enjoyment of our human rights. But 5% of patents are there, which are no way contributing our human rights. Can anybody tell me what are those 5% of patents? Anybody having any clue? Around 95% of patents will definitely contribute our human rights enjoyment. But 5% of patents are there. They are not at all going to contribute anything to us, to the public. Can anybody tell me what is that 5%, where it lies? Any teachers can attempt because it's related to teachers. Any idea?
Yes,
No.
participant, you can put it in the chat box or you can unmute yourself.
Yeah,
We-
somebody made a comment. Let me see.
Weapons.
Uh, no, weapons are also contributing for our human rights because we need weapons. Then only our country will be safe. Otherwise, people will attack our country, and our position will be like other countries. That cannot be allowed. So weapons are required. And nuclear weapons invention, that is also something very important for human life. Nuclear energy, that invention is very good. Harmful gases, that is also one way or other way contributing. I will tell you. Simple. There are certain patents which are taken by teachers, including law teachers. Some of the law teachers having patents. Some of the university and college teachers having patents. And they have obtained that patents only for the sake of obtaining patent. And they are no way going to commercialize it. And that product may not be possible to commercialize, but only for the sake of getting a patent in their name and the consequential other benefits. They have taken this patents. So that is what that 5%. So 5% of patents which I intend to say is those patents taken by teachers for the sake of their career advancement schemes. Okay. Now, other than that, as I said, 95% of patents are in one way or other way contributing our enjoyment of human rights. Now, specifically, I can tell you the right to health, which is guaranteed as a civil and political rights in number of international human rights documented. Now, you know very well, in medical technology is changing every day. Medical technology is changing, and large number of innovations are happening in the medical field, especially in the case of life-saving drugs or vaccines or some other medical equipments and everything. So when these type of new drugs, new vaccines, or medical equipments or devices, etc., are being invented, now, what is the encouragement for innovation? That is, they will get patent and they will be able to commercialize that particular patented item. That is why they are inventing it. But that inventions will help us to enjoy our right to health. So we have large number of patented drugs, patented medical devices, etc., 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 etc. And all these are contributing to our enjoyment of human right to health. Now, other than right to health, we have right to education, something which is directly related to patents because there are large number of educational tools were created. Even now, we are talking about talking through an online platform. This is also a patented technology which is developed by some of the inventors. So, like that, right to education will also be protected. Then, right to work. This is most important thing. Whenever a person, suppose I am taking a patent over a particular product, then I am entitled to commercialize it. Obviously, I cannot alone do that. I will have to start a business. That is a startup, either a small or medium type enterprise. Now, when I start that, along with that product is going into the market, and that will help the consumers in some way or other way. Other than that, my patent will create jobs. So whenever a patent is being given, right to work, that will also be protected to large number of people. Now, when right to work is creating job opportunity, the standard of living of those employees will automatically improve. So simply by conferring a patent, if that patented item can be commercialized or industrialized, then that can offer lot many things for the enjoyment of human rights. Directly, that product will help, plus indirectly, because of the manufacturing of the product, distribution of the product, for all level, large number of people will get opportunity to interact, and they will all work, and they will all get the benefit, and their standard of living will definitely improve. So that way, right to work will also be realized when there is a patent. Then, right to cultural participation. This is another direct benefit of having intellectual property rights. Like, there are certain unique cultural products, and that can be protected in the name of patents. Some unique products or unique items which can be invented. If it is very useful for culture, then your human right to participate in cultural activity will also be protected. I'll give you one example. Now, we are going to have Onam celebration in our state. And we have a cultural practice. We used to keep a statue, which is an indication of Onam Tappan. That means Mahabali. Now, that statue can be patented, or as of now, it is not patented, but it can be. That type of things, if you are inventing, that will be patented, and it will help you to utilize your cultural participation. Then, another important thing is right to a healthy environment. This is another benefit of having patents. Now, green technologies can be invented, and the encouragement is patent. Then, sustainable practices can be encouraged. These two aspects will ensure your human right to a healthy environment. Now, if I am inventing more and more technologies to reduce the smoke or emissions or the discharge of wastewater or treatment of wastewater, treatment of waste, liquid and solid, then automatically your right to healthy environment will be protected. So by getting a patent, or because of the encouragement of patent, I will innovate, and that innovation will leads to ensuring your right to healthy environment. So that is another advantage. Then right to access to information. Now, because of the incentive of patent, people are innovating, and that innovations will leads to developments in communication technology. Now, you all must be remembering the technology of Volt. Now, this Volt technology is also invented by somebody. Now, what is the advantage of having Volt technology? Our freedom of speech and expression is protected. We will be able to exercise our freedom of speech and expression without much cost. Because when Volt technology introduced, the voice call charge is reduced. Now, in most of the case, you are charging for, in smartphone, you are charging for data only. You are not charging anything for the call. It's unlimited. Any number of hours you can talk. But earlier that was not the case. Now, how that is possible? Because of innovation. Why innovation? Because of the attraction or incentive of patent. So that way, right to access to information, that will also be protected because of patents. Then all these things will improve the quality of our life. So when the incentive or encouragement in the name of patents are there, people will innovate, and that innovations will definitely improve our quality of life. And along with improvement of our quality of life, the national economy will also improve. Now, when national economy improves, the government will be able to utilize more and more money for the infrastructure development, etc. And that will also help us, that will also protect our human rights. So, because of all these reasons, we can say patent is having a complementary relation with our human rights. But at the same time, the patent is having a conflicting relation also. Now, how this conflict arose? Simple. You all must be knowing when we use patented items, it will have a very good cost, especially when it comes to a life-saving drug or a medicine or an instrument, the cost is very high. The patent owners will charge very heavy fees or very heavy price. So that cost of patented medicines will deprive large number of people from accessing that particular product. So that is one of the conflicting relation with our human right. Second method of conflict is limited access. Now, there are so many instances. If you are having a patent, even if your patent is useful for the public, you may not, or you are not ready to produce it, or you may not be making it available to the required number to the consumers. So that limited access problem may happen when it comes to patents. Then restrictions on educational material. Now patents are there, innovations are there, that will help to enjoy your right to education. But at the same time, there are lot many restrictions. And if you want full access, you need to pay. So even though it is there to help you, but sometimes there will be restriction. Then exploitation. That is another important aspect of sorry. Another important aspect. Just a second. Yeah. Another important aspect is exploitation of traditional knowledge. Now, in the name of patents, in the name of innovations, people may try to exploit your traditional knowledge. Like we are all aware of the issue of basmati rice, our neem or vastu vidya, etc., where some people are trying to take the advantage of our traditional knowledge and thereby they will take patents. And once patents are taken, then nobody else can be used without the consent of the patent owner. So that way, the traditional knowledge will be exploited. So that will also comes in conflict with our human rights. So these are the conflicting relations of patents with human rights. Now, coming to copyrights, whether they are having complementary relations or not. Now, copyrights also encourages or helps us to protect our number of human rights. As we all know, our freedom of speech and expression will be protected. Then it incentivizes the creation of new works, including literature, music, etc., etc., etc. So, because of these reasons, we will be able to enjoy various social rights, like right to entertainment, right to rest and leisure, right to music, right to listen, right to read, whatever rights are there, which we need to have enjoy under the heading social rights, you will be able to enjoy with the help of copyrights. Even cultural rights, which are conferred under our International Covenant on Socio-Economic and Cultural Rights, most of these cultural rights you are able to enjoy with the help of copyrights. Again, right to education. That is another important right which everyone can enjoy with the help of copyrights. So, in this sense, we can say copyrights protects our human rights. Number of rights are being protected. But at the same time, this copyrights also having a conflicting relation with our human rights because of the restriction to use. We all know once a matter is copyrighted, you cannot use it without the consent of the copyright owner. And to an extent, for educational purposes, you may use it, but for other purposes, you may not be able to use. So that restriction will come into picture. Even you might have heard about the issue of one of the famous music director. He used to argue whatever songs he has given the musics, nobody should use it. Even for a musical program, you are not supposed to use that song. If you are using that song, you have to give royalty to me. Now, that way, this copyright can restrict your use. So, we can say copyright is also having a conflicting position with our human right. Now, coming to trademarks. Now, trademark is also having a complementary role. Now, interestingly, trademark is given to a brand or a name or a logo or a visible any other visible representation. Now, what is the significance of us for having or knowing the trademark? Being a consumer, we can identify the origin of the product. That is one of the important significance of trademark. So if a person having a trademark, if a company having a trademark, then when they use that trademark in their product, we the consumers can make sure that that product belongs to that particular brand or company or producer or manufacturer. Now that is an assurance for a consumer that it is not a fake product. It is the original product. So that way, trademark will ensure consumers a fair, what we can say, uh, the trademark can provide an assurance to the consumers about the origin of the product. And why we are looking at the origin of the product? Because we know this particular brand is having quality or standard, etc. Now, because of that, we are preferring a particular brand. Now, once we are getting the original product, and we will be able to distinguish or identify using the trademark, our right to choose, right to access, right to standard and quality products, etc., is being protected. So, trademark is also having a complementary role with respect to human rights. But at the same time, trademark is having a conflicting role with respect to human rights. That is, trademark can create unfair trade practices. That is actually something which adversely affects the rights of consumers, including our human rights. Now, how this trademarks will encourage unfair trade practice? Now, when you open the Google, you can find some websites. They are selling certain products with a brand name. Say, for example, suppose you may see an advertisement 20,000 mAh power bank of Sony is available for just 300 rupees. Now, if you see the image of that particular product, everywhere it is written Sony, and that font style, everything is Sony. So you may tend to purchase that, thinking that since this product is having the logo of Sony, it may belongs to Sony. And that is actually an unfair trade practice. It may not be the original product, and you will suffer a lot. So that way, trademark can also conflict with enjoyment of our human right. Then comes anti-competitive practices. When trademarks are there, when companies having brand name, logos, and other identifiers, then definitely, as I said, consumers will choose which brand they wanted or which manufacturer they wanted. Accordingly, they will buy. That will create unfair competition in the market among the market players. And then to achieve more consumers, the market players will start practicing anti-competitive practices or restrictive trade practices. So that way, when a manufacturer or seller or other market player practices anti-competitive activities, that will adversely affect consumers. Maybe initially it is good for consumers because they may get some discount or something, but in later point of time, consumer will be the real sufferer. So trademarks can also cause conflicts with our human rights. Now we have seen the major three IP rights, that is patents, copyrights, and trademarks. And other than that, we have several other other intellectual property rights like designs, etc., integrated circuits, etc. I'm not going to tell you that. Now, considering these three major IP rights, what is our conclusion? Whether IPR and human right is having a complementary role or contradictory role. What you say? Now I have explained to you how it is complementary and how it is contradictory or how it is conflicting. So what would be our conclusion? Whether it is complementary or contradictory? Somebody can respond, then we can proceed. Anybody?
Yes, participant, you can unmute yourself, or you can raise your hand or put it in the chat box. Any question, query?
I think there were two questions in the chat box. One is from Yogesh. Yogesh wants to ask whether our research materials or thesis can be patented. No, no, no. See, actually, it is a literary creation. So you can get copyright. If it is your own creation and if it is your own sentences, that is, if you have not copied from somebody, you can apply for copyright and you can get it copyrighted. But the thing
Sir,
is, if you are submitting a thesis, then the copyright may be with your university. So you make sure that whether once you submit a thesis, whether you can take copyright over it. If your university permits that, you can very well get a copyright and you can directly submit the same to the copyright application. Sorry, you can submit through online, you can submit a copyright application and you can thereby get the copyright.
sir,
Now,
can I
another
take
question
your
is there.
2 minutes to further discussion on this?
Yes, please.
Sir, this is regarding like suppose if I am creating myself for like suppose if I am pursuing the PhD and I am
Okay,
writing on the particular one subject, maybe like
okay.
suppose if I mention here right to truth. Now
Mhm.
it is unexplored area in India, and
Okay.
I'm searching on that. I'm investigating that. I'm doing all these things. So can it be like I have the copyright that this subject is explored by me, whatever money or time or efforts is put in by me. So suppose if this come to know by any other student or any of the lawyer or anybody in the judicial system, they can suppose if it's not patented, they can take it and they can give this material for the getting the publishment in the newspaper or somewhere else. So
No,
this was the
see,
topic. Just I wanted to understand with your help.
yeah, I'll tell you, I'll tell you. Actually, you are talking about a literary work. For literary work, you cannot get patent.
Okay.
Patent is for a product.
Okay.
Patent is for a product. Okay. Are you are saying research material or thesis? That is actually a literary work. For literary work, you can get copyright. Now, the interesting thing, what we used to do when we write an article or when we write a chapter, we will get it published. Once we will publish it in a journal, that particular material will be our copyrighted matter. Nobody
Okay.
else can reproduce it without our consent.
Okay.
You
Got it.
cannot keep it a secret because if you are whatever findings you have made, you cannot keep it a secret. If you're keeping it a secret, there is no point in that. Only thing is you want the ownership to say that you are the person who explored this, and for that
Service.
you can publish it in some journal. Then you will get the copyright. Again, when you are submitting a paper to a publisher, you make sure that whether they have a copyright transfer agreement. If you are transferring your copyright to that journal, then journal will use your work without your consent. But some of the journals will not ask that copyright transfer. Then whatever article you are publishing, you will still hold the copyright with you. So you can use it.
Understood, sir.
Clear?
Thank you, sir. Thank you, sir.
Yeah.
Thank you, sir.
Now, Poonam has asked the question that is, why patents protects human rights only for 20 years? And if it is not renewed, then the protection is diluted. So why on condition-based human right? It's not like that. See, for every patent or every intellectual property rights, there is a time period. Now, why we are giving patents to an inventor? Because he is investing his time, money, and hard work and intellectually creating something. So that is why, as an incentive to create more and more things, we are giving patents to it. Now, 20 years is given to him. Exclusively, he can use it. He can commercialize it, excluding all others. So, by 20 years, he will be able to exploit his invention. And once that 20 years is over, this product will go to the public. Any person having the knowledge, if they know how to make that, they can use it. So in both way, it is actually a balanced approach. So 20 year, it will help the inventor, and after 20 year, it will go to the public. So public human rights will be protected by using 20 years, and even after that also. And at the same time, 20 years he can exploit his invention. He will get the benefit. That is why this 20 years period is given. Then biopiracy, which is linked to human rights, is dealt with strictly. Now, regarding biopiracy, we have a legislation very specifically. We have our Biological Diversity Act. Now, as per the provisions of Biological Diversity Act, if you want to take any genetic resource from India, you have to get protection. Sorry, you have to get consent. You have to take permission from the State Biodiversity Convention, State Biodiversity Commission, as well as National Biodiversity Commission. So only after going through the consent requirement, you will be able to obtain any genetic resource from India. Now, if you are obtaining a genetic resource without obtaining the proper consent, that will amount to an offense. So India has already made a legislation, and because of that legislation, people cannot do biopiracy now. And if you do it, that will amount to an offense. There will be criminal punishment for that. Clear? Then there is one question from Nalini. Instead of publishers who restrict readership to those who can afford to buy expensive journals, can we not publish under Creative Commons? See, the point is very tricky thing this. When you want to publish something, where you will publish? You may need to, because we are publishing it for the public. Now, how public will come to know about our publication? Some publishing house has to interfere. And with their money, they will publish or they will print it and they will make ready this publishing matter and they will circulate it. Because of that, it will reach to the public. Now, when a publishing house is interfering there, they will definitely require the expenses of that. That is why they are charging it. It's not simply because they are charging without any reason. It is for their expense. Say, for example, I am writing a book consists of 250 pages. Now, anybody can say, why can't you circulate it free of cost? Now, how I will circulate it free of cost 250 pages? If you want it in the form of a book, somebody has to print it. Somebody has to bind it. Then you need a cover page for that. Then you need all typesetting and page setting, everything. For that, there is expense. At that expense, they will try to cover up from the readers in the name of the publication fee or some other way. So that is what this price. So don't think those who are charging is restricting our readership. It's not actually a restriction. It is actually for their survival too. And maybe there are some publishers, they are charging more. That is different thing. Okay, so we were in the position IPR and human rights is having both complementary and contradictory relationship. Now, the interesting thing, when we discuss the interface between human rights and IPR, there is a problem in fact. IPR is also a human right. Then how we can discuss whether one is having any complementary or contradictory relation with another? If you go through Article 27 of Universal Declaration on Human Rights, it very clearly says that everyone has the right to freely participate in the cultural life of the community, to enjoy the arts, and to share in scientific advancement and its benefit. So this particular article talks about intellectual property rights in both sense. One, as human beings, We have fundamental human right to enjoy the arts, to share the benefits of scientific advancement. Now, how you can enjoy the arts? Somebody has to create it. How you can take the benefit of advancements in scientific realm? Somebody has to invent it. So Article 27 clearly says IPR is a human right. And at the same time, it is indirectly saying you are having a right or you are bound to. Even I can say it is a duty on the part of those who are able to invent, those who are able to create. If there is a duty for the sake of human rights or protecting human rights of large millions, you are bound to innovate, you are bound to create. So that obligation you can find in Article 27. Likewise, if you see Article 15 of International Covenant on Economic, Social and Cultural Rights, again it says everyone has a right to enjoy the benefit of scientific progress and its applications. Now, how we can enjoy this? From where we will get the scientific progress? Only through innovations. Now, who will innovate? Those who are getting IP protection. And if you are not getting any IP protection, I don't think anybody will try to innovate. And even if at all, if he innovates something, that may not be a useful innovation. People will innovate useful innovations, or they will explore or they will identify scientifically, or they will encourage scientific progress because of the attraction of intellectual property rights. So if you want to enjoy the benefits of scientific progress and its application, definitely there must be some people who has to innovate. And that innovation happens because of intellectual property rights. Then to benefit from the protection of the moral and material interest resulting from any scientific, literary, or artistic production with, of which he is the author. Now, this article very specifically says if you are inventing something, you have the right to take benefits over it. So, Article 15 having two limbs. One, being a normal human being, you have the right to enjoy the benefit of scientific progress, which is because of innovations. Secondly, if you are being the reason for any scientific progress through innovation, you have the right to get protection or you have the right to take benefit of that particular moral and material interest resulting from such innovations or literary or artistic creations. So we can say IPR is a human right. Or in other words, IPR is also included as a part of human rights. I hope that is clear. Any doubts regarding this? Any doubts? If you have want any clarification, you can ask. Otherwise, we'll proceed further. You can just put it in the chat box. Okay. So somebody represented the audience and said no doubt. So we will proceed further. Now, if you see the General Comment number 70 of 2005, issued by ICESCR, as well as Universal Declaration on Bioethics and Human Rights 2005, then the another document is there, very statement on the right to enjoy the benefits of scientific progress and its applications 2009. Then recommendation on scientific science and scientific researches 2017. Finally, the report of the special rapporteur in the field of cultural rights on the right to enjoy benefits of scientific progress and its applications. All these international human rights instruments very specifically emphasizes that intellectual property rights and human rights is having a complementary role as well as contradictory role. Now, complementary role is manifest because every innovations, every literary creation will help the common man to enjoy his human rights in one way or other way. At the same time, it is having a contradictory relation. As I said, it may lead to problems in the market. It may lead to increase the cost of product cost like that. So there are contradictory issues or conflicting issues. But in reality, if you analyze or if you are balancing the positive versus negative or merits versus demerits, I would definitely say IPR and human right is having only a complementary relations. Even though there are some conflicting areas, that conflicts can be very well avoided. You might have heard about the famous cases which was happened in IP law. One of the case where a patented drug was there, which is very costly drug, but the company was not ready to export the same in India or produce in India. Now, one another company requested for compulsory licensing. Now, they are not ready to issue compulsory licensing or license. Then they approached the Supreme Court, and the Honorable Supreme Court allowed compulsory licensing. As a result, the second company will able to produce the medicine in our country or distribute the medicine in our country in a very cheap rate. Now, that way, even though the intellectual property right poses certain threat to our enjoyment of human rights, still using the legal mechanisms, we can able to cover up that. So if that be the case, we can tell you, or I can tell you, intellectual property rights is having a complementary role in realization of human rights. So that is what my conclusion on this particular debate. Now, when we say complementary relation, as I said, the legal framework can resolve that conflict because there are certain areas where patent rights can interfere with human rights, copyrights can interfere with human rights, trademarks can interfere with human rights. Therefore, all these, we have remedies. Our legal framework provides remedies. Whenever there is violation of human rights, you have remedies. And if you feel that such conflicts causes any violation of fundamental right, you have remedies. If you feel that such conflict causes any violation of statutory right, you have remedies. So since our legal framework is there to provide remedies for violation of human rights, violation of fundamental rights, violation of statutory rights, I can tell you whatever conflicts are there or whatever threats are there on the part of IP rights, it can be very easily controlled. It can be very easily managed. Thereby, we can ensure that the human right is being protected. So this is what my observation about the question or the topic interface between intellectual property rights and human rights. Now this floor is open. Anybody want to make some comments or some doubts or questions, whatever you have, you can please ask. If anybody want any clarification, you can ask. If you have anything more to add, most welcome.
Yes, participant, you can raise your hand or you can put a question in the chat box. We have about 10, 12 minutes. Yes, please.
So I'm expecting some. Yeah,
No,
please.
please. Yeah, carry on. Gangadhar.
No, I was expecting some questions. I thought there will be some interactions. That's why I
Good
made
to
a
hear.
small presentation
No, it's
because
good
it
to
is the
hear.
evening time. It will be very boring if I keep on talk.
Yeah, sure, definitely.
So I wanted to give some time to the participants because
Perfect.
some of them may be more expert than me on this topic.
Yes, Hafsha Rashid.
Good evening.
Yes, Gangadhar Rao, are you there?
Sir, IPR rates are only for 20 years. Now, beyond 20 years, can we renew that one in the same name or not possible?
No, in patents you cannot. Patents you cannot. You can have only for 20 years. But when it comes to
Okay.
trademarks, you can renew it. But that is for initially for 5 years, then you can keep on renew it. But for patent rights, we cannot renew like that.
Okay. Thank you.
Yeah, next, Hasfa Rashid.
Hello, sir.
Yes,
Yeah.
please, please.
So, sir, when you told about the patents and copyright of book that can invade our human right, I would like to know about it very in detail. Like I am myself an author, so it just makes me like how can copyright infringe the human rights?
See, one important thing is, suppose you are publishing your research work in a journal. Now that journal is not freely available to the public. Now you may be the person who done the research on that topic and your research is an excellent research. But without subscribing that journal, subscribing means by paying huge amount, nobody else will be able to read it. So being an average reader, I may not be able to subscribe by paying that much huge amount. Then that will adversely affect my right to education or right to information or access to information. So that way, sometimes it can cause interference with our human rights. That's what. Clear.
Thank you, sir.
Even otherwise, you see, when you are, suppose you are a student or you are a teacher, when you are researching something in the Google, you will get only abstract. You won't get the full text. And while reading that abstract, you may feel like getting more and more information. But when you click on the full paper, they will ask subscription. Now, for preparing an article, we may read 10 or 15 or 100 articles. Will it be possible to buy all that 100 articles just for preparing one article? So then it will be considered as an interference with our right. Clear?
Next question is chat box. Sir, as a IPR is a human right, so whether the Human Rights Commission has any role for its violation?
Unfortunately, Human Rights Commission having no role when it comes to human rights and IPR. The problem is if the IP right is vested with a government or a public servant, government entity or public servant, definitely Human Rights Commission can interfere. Why? Because that is one of the very key points you must remember when you are undergoing something on human rights. You cannot claim human rights against a private person. In our country, if you go by our Protection of Human Rights Act 1993, you can claim human rights only against public servants. Or in the when there is a negligence on the public servant, if your human right is violated, then also you can claim. So only two situations in India you can claim your human rights. One is there is a violation by a public servant. Second is there is a violation because of the negligence of the public servant. But interestingly, when it comes to IP rights, these are vested with private people. So if they use their IP rights, I think you cannot approach Human Rights Commission. Clear?
For sure. Yes,
Sir, I would like to put out one question. Good
Yes.
evening. I am Dr. Priya Gupta. My question is that regarding the intellectual property rights specifically, do we have any legal codification here in India? And if yes, how far do you think is effective? And also, could you also throw some light upon the international instruments that concern the intellectual property rights, and whether India has any affirmation to the same or not? Yeah.
See, we have codification. We have Patents Act, we have Copyright Act, we have Trademarks Act, we have Integrated Circuits Act, we have Plant
Right.
Varieties Act, we have Seeds Act. All these are protecting intellectual property rights of different aspects. At international level, the most important document is our TRIPS, Trade-Related Intellectual Property Rights. Then Berne
Mm.
Convention is there. Like that, so many other instruments are there. Plus, we have an agency, World Intellectual Property Organization, WIPO. So they are regulating various aspects of international law relating to IPR. So we have an excellent codification both at international level as well as national level, and it is
So,
working very well.
now, how far is the implementation? If we have the codification, are they implemented fine, or are there still
Yes,
some
yes,
little
yes.
gaps?
Yes, yes. Our country is actually far ahead than the international framework. If you go through the TRIPS agreement, in most of the case, TRIPS agreement says the countries can have their own system. That is sui generis system for protection of intellectual property. Now, India have adopted all these things, almost all the provisions of international law, and we have created much better system than any other country compared
Mm.
to our neighbor countries or most of the other countries. So we are implementing, and even our legislations are undergoing several amendments to make it more in tune with international instruments. So there is
Mm.
no, I think we are implementing it in a very effective manner.
Okay, sir. Thank you so much, sir. Mm.
Okay, thank you. There is one question.
Yeah, this will
Does delay in resolution of human rights cases can be solved? Unfortunately, no, it's not. Delay is a problem everywhere that we cannot solve it because it needs a multi-dimensional approach. Just by one magic stick, you cannot remove the delay. Delay will happen everywhere, but based on this modern technology and people's awareness, the delay will automatically remove. Otherwise, we don't have any solution. You may be knowing we are seeing delay in our lower courts, even Supreme Court, High Court, even consumer commissions you are seeing. Though it is mentioned 5 months to settle the dispute, it will take 3 years to settle. So these systems are created for speedy disposal. There are so many systems for speedy disposal, but you cannot avoid the delay because this delay is caused by we the human beings only. It's not by the court, it is the human beings. I'll give you one simple example. Suppose a matter is filed before the commission. Commission may fix commission may fix the hearing date on 10th. And on 10th, you will file an application for extension saying that you are not well or you are having some other urgent issue, so may not be able to appear before the commission. So commission will postpone this matter to another 2 months. And in that 2 months, the other party will come and claim the same. So again, it will be postponed. And then both of you may appear after 6 months or 1 year. Then you may refer some document which is there in the government office or something. Then the commission will post this for getting that document. That document will take minimum 6 to 7 months to reach. So by the time your case will go more than 2 years. So this delay is procedural, and you cannot overcome this procedure because these procedures are there for fairness and to ensure justice. But when we look at this procedure for fairness and justice, it may cause delay. That is bound to happen. We can't avoid. But to an extent, we may be able to avoid, but not completely. Yes. Any other question?
yes. I think we are done with. Yes. Thank you, participant, for all the insightful, thought-provoking question, and thank you very much, Dr. Anish, for the insightful session. I request Dr. Priya to give a vote of thanks to you.
A very good evening, sir. Sir, we are so grateful to you. First, you agreed to come up for this lecture just in a moment, without showing any kind of inhibition. And then the session was so insightful. we could see a side of IPR and the correlation between IPR and human rights, which we have never heard of before. So we've got a new information from you today. So we are really looking forward in more of such sessions with you. And thank you so much for showing up. And thank you so much for taking out time for this session. We are really grateful, sir. Thank you, sir.
Thank you. Thank you so much for the
Thank
great
you. Thank you,
opportunity. In fact, this is though I am dealing with human rights, first time I am trying to interfere with IPR, in fact. So it's uh, what we can say, it's an experimental discussion, in fact. So thank you
Definitely,
so
yes.
much for
Sure,
this
sure.
opportunity.
Definitely. We were discussing with Dr. Priya, like, this is very unique thing because emerging trend that we are discussing. And I also got opportunity teaching IPR. I have done LLM business law, but there's one paper in IPR. So I'm not an IPR expert.
Okay.
So in that time, like while teaching patent law, so we keep discussing, there is connection with patent, especially patent, not with other branches that what you have discussed. Every branch you have taken up and then discussed. So patent, like I remember one of the fire in the blood. It's very prominent, documentaries there. But the African, that's drug related same thing that you talked about, like compulsory licensing. So very good. I watched around 12 years back. It's a very good eye opener, like how patents connection with this human rights. So great connection. So thank you very much, and look forward to see you in future events. Yeah, thank you.
Thank you. Thank you so much. Thank you so much. Thank you
Thank
so
you.
much.
Thank you,
Uh,
Nazreen. Yeah, please, please.
for the audience, we will be looking forward to see you tomorrow at sharp 5 p.m. with Miss Avni Verma. So see you all tomorrow. Thank you so much.
Thank you. Thank you.